which impacts a lot of the existing or prior trusts, and it leads into the idea of making sure to review trusts that were set up in the 90s, that were set up when the estate tax exemption was much lower than it is today at 13 million, going up likely to 14 next year. So a lot of the trusts, or the trusts that create irrevocable trust upon one spouse's death, may not make sense anymore because the exemption has gone up, and the size of the estate is not anywhere near that $13 million exemption, or in a married couple situation, 26 million. So we're looking today at fixing obsolete irrevocable trust, or ways to ensure that the trust or the estate plan is essentially reflective of the current estate tax exemption. So we know that, again, the exemption amounts have changed. We also know in 2026, the exemption is going back down to roughly 7 million. So it really is a moving target, unfortunately, but it creates a lot of business for us planners at this point. It's been busy in the last year going into next year, as people are looking at maximizing their estate and gift tax exemption and locking it in, but also with looking at prior, again, outdated estate tax or trusts that plan for these bypass trusts to exist at the time one spouse dies, requiring the trust to split into two shares. And as Larry mentioned, the B trust, or the bypass trust, does not get a second step up in basis when one spouse dies. So essentially, that capital gains tax is triggered when the surviving spouse passes. And while that bypass trust was exempt from inheritance or estate tax, it's subject to a capital gains tax if that asset, or that Navigator stock, as Larry mentioned, is sold at the time the surviving spouse passed away. So there are other ways to capture the exemption that when one spouse dies, such as portability. So essentially, you need to look at what is the best way to create a structure of this trust that maximize both the estate tax exemptions, but don't ding the family with capital gains tax on the survivor's passing. So those traditional AB trusts set up in the 90s really are truly, in many cases, outdated unless the client's estate exceeds the exemption, which is rather high right now. And I think also Larry mentioned modifying an ongoing kind of dynasty type trust that we'll discuss a little bit later, that keeps the assets in trust for multiple generations, but the size has whittled down. And again, the estate tax, or what we call generation skipping transfer tax, or GST trust, it really isn't relevant anymore. So we'll talk a little bit more about that as well too. So here's where we're at. And this only goes up to 2022. So in 2023, the exemption is a little over 13 million. They'll apply another inflation rider for that in 2025. So, it's not, I call this champagne problems, is really not effective for most of the clients looking at, an estate tax issue. They're really setting up a trust, maybe avoid probate. So ensuring it's properly funded is very important. They're also, maybe holding assets in trust, not for tax purposes, but for asset protection, or they don't like who their son married, spendthrift provisions and things like that. But again, you need to watch it because the exemption is scheduled to drop likely about roughly in half, depending on the inflation rider applied after 2025, heading into 2026. So it is kind of definitely a fun time to be practicing right now, as we're seeing a big potential change in the law. So going back to the traditional AB trust that requires the trust to split up on the first spouse's death, and that bypass or B trust being funded. Again, if the estate tax exemption or other ways to capture the exemption, such as portability. Portability is a mechanism where you do not need to utilize the bypass trust. You can file an estate tax return and elect portability, where I describe it as essentially the surviving spouse is transporting over the deceased spouse exemption to them. So again, if I pass away this year and I have a $5 million estate, it really doesn't make sense for all of the administrative burden of a bypass trust I'd rather have my spouse elect portability, but there may be some other reasons I still decide to have a bypass trust. So at the end of the day, it really is a case by case basis. And you also may want to be looking at Clayton election trust, where you require the trust split, but you get to toggle between a bypass trust or what is also known as a marital trust. It takes advantage of the unlimited marital deduction that Larry was mentioning that was created in the 80s. That concept allowed you to create an irrevocable trust after one spouse passed away to lock in the deceased spouse's wishes. But essentially, that marital trust would be includable in their taxable estate when the survivor dies, so look at the step-up basis. So I do have clients who still want to create an irrevocable trust when one spouse passes away because they want to lock in their wishes if they're the first to go. They may be may have a blended family situation where they have kids from different marriages. So they want to just be sure that they're protecting their kids. But the traditional bypass trust, without exploring other more flexible options to allow for the second step basis, may make more sense than, again, the traditional bypass trust. So if you're stuck with a bypass trust after someone passes away, I believe as mentioned earlier, you can terminate the bypass trust. You can go to court and say, it doesn't make sense. Circumstances are changed. California, there's a probate code section that says, due to changed circumstances, we can ask the judge to terminate it and not continue to maintain that and have everything be brought back into the surviving spouse's taxable estate. Now, that does mean the survivor could change that survivor's trust. So why would you want to keep the bypass trust? Well, you may want to ensure, the client may want to ensure a legacy for the remainder beneficiaries. And this is an interesting one. Irrevocable trusts have a inherent asset protection component. Because by virtue they're irrevocable, they're limited to what's called an ascertainable standard of distribution. A bypass trust will use typically health, education, maintenance, and support, which is broad enough for the survivor to be able to pull it into their, use assets, but not a free-for-all where they'd have to, again, the IRS says that's enough of a standard to limit the ability for them to access it, so it's not includable in their taxable estates, and it's not available to most creditors. So while it has some administrative burden and expenses, it may actually be something that the client feels is good for from an asset protection standpoint as well, too. So here's a very, I would say, a complex tax that I would say most attorneys and CPAs don't understand. So I'm going to try and explain it to everyone today in a way that I explain it to my clients. So when I create a bypass trust, I'm using an estate tax exemption. And I may also be using the generation skipping transfer exemption to shelter that bypass trust from both estate taxes and generation skipping transfer tax. So at the end of the day, I can plan for multiple generations receiving assets, both estate tax and GST tax-free. What happened, I think, basically the best way to describe how generation skipping transfer tax came about is these bypass trust or dynasty type trusts were essentially created in order to go on for multiple generations without having to pay an inheritance tax or an estate tax. So the government kind of said, well, wait a second, this is going on for multiple generations, and absent, I guess, the rule against perpetuities that says this trust eventually has to expire, we don't get a chance, another bite at the apple to take the tax on this trust, because it's held with this irrevocable trust that is, once it's free from an estate tax, it continues to be for multiple generations. So they said, forget that. We're just going to make up essentially another tax that says when it starts to hit these lower generations, what we call a skip person, we're going to levy another tax. The good news is the client has an additional exemption from GST. So I can allocate that GST exemption and the estate tax exemption to that bypass trust or that ongoing dynasty trust and make it exempt from GST tax up to in 2023, 13 million. But there are two potential transfer tax or wealth transfer taxes that you need to be aware of, and GST is one of the more complicated ones. So again, sounds great, but then when you have these GST trusts that have been sort of diluted over multiple generations, it may be necessary at this point to terminate it because the children's estate are nowhere near the estate tax exemption amount. So they want the assets to be includable in a taxable estate so that they get that step up in basis upon their passing. You have the same administrative complexities for these ongoing dynasty trusts that are GST exempt. So you have the cost of filing that return and maintaining the trust. And again, that step of basis is probably the driver behind it. But I always tell people be careful because for what you wish for, because again, you're going to be giving up this pretty amazing asset protection component. So when we do dynasty trust planning, when we're gifting to lock in an estate tax exemption, we try to look at assets that I think are legacy type assets that we're going to put in this ongoing trust that we hope the family will keep for multiple generations. I'm working on one right now, literally right before reviewing a trust that will hold a large ranch up the coast of California. And this ranch now is very, very valuable for some kind of nuanced reason. And when I say very, very valuable, we're talking about hundreds of millions of dollars. And they don't want the family just starting to sell as it starts to go to generations. They're trying to lock it up and create this really nice stream of income for multiple generations. So ultimately, this would be the goal. And it's large enough that it probably makes sense to do it. And it's not one of these smaller trusts will get diluted. So this kind of legacy type asset makes sense to put into these generation skipping trusts. But at some point, as they whittle down and the value gets lower, you may want to go to court to terminate it for the reasons listed on this last slide and discussed. So how can you logistically terminate or modify an irrevocable trust that just doesn't make sense anymore? And I've touched on this already a little bit. You can go to court and petition the court. You can also look at the trust terms, and that's where you want to start. I always tell my clients, we want to avoid court as all possible. It's just not the most efficient way. Although I'm here in LA County, and for the most part, judges are very reasonable with understanding the reasons behind terminating it. So they're not looking at it of like, oh, you want to, overstep what the donative intent, the grantor's intent was. But they're really, if everyone agrees and is on board with the petition, they really tend to be very supportive of these types of petitions. But you can also look at a power of appointment, and a power of appointment is a way to be able to say, through the beneficiary's trust, through the beneficiary's will, where the assets go upon their death. And so you could be able to say, oh, is there a way that I can say upon my death, this just goes out to my children outright and get rid of this trust, at least when I die. Sometimes the trustee, but more likely like a trust protector or maybe a special independent trustee has the power to amend, which is great. I mean, I like to incorporate a special trustee or a trust protector in every irrevocable trust I draft because it often is a great workaround to having to go to court. Sometimes if you get this at a point where someone is just receiving it as a beneficiary, maybe they can disclaim their interest and have it, bypass them and go out right to the next generation. And there is a probate code section that allows it when it gets below a certain level to just terminate because again, it's not economical anymore. So before you go to court, you want to look at are these other unique provisions. And of course, if you set up an irrevocable trust while you're alive, California also allows for modification with everyone's consent through just an agreement. So that's another option. But once the grantors have passed, or even one of the grantors has passed, they can't sign off on it anymore. So we're looking at other creative ways. So I just mentioned that by settlor and by all beneficiaries, but the settlors still need to be alive, obviously, to do that. So a lot of times we're getting these later down the road when someone has already passed away. We do have a decanting statute in California. It's just not as flexible as many of the other states. And decanting is just a way of taking one trust and essentially, just like you would decant a bottle of wine into another structure, you would take it from the original bottle and put it into a decanter. You put the assets into a new structure, a new trust, essentially. But there are a lot of restrictions you'd want to look at before doing that. For example, you'd want to, look at the probate code and make sure that a lot of things have to mirror in the new trust that you're decanting into. So again, it's not quite as broad as, let's say, for example, I've worked with a case in Arizona where it literally can kind of just go anywhere at any time, which is kind of interesting. And I think obviously the idea is blending, okay, this was the grantor's or settler's intent versus changed circumstances and the ability to have flexibility as time changes and things do go on. This is really important. If you are terminating a trust or modifying a trust, however the mechanism you're doing it, you need to look at whether it violates the no contest clause. And then no contest clause provisions in the estate, which says if you don't like the terms of this trust, this is not normally how you think of a no contest clause triggered. Normally it would be someone contesting the terms of the trust, but even a modification could be considered a contest and trigger these terms, which would be obviously very problematic. And if the beneficiary becomes the trustee, perhaps you want to look at, well, what are the trustee's powers? Again, does this overstep the original grantor's head? And again, if you're getting rid of an irrevocable trust, are you getting rid of this, Spencer provisions and the asset protection that goes along with it? Because you may want to think twice about doing that before you go and terminate this and get rid of the structure. I think sometimes you'll find beneficiaries or clients or whomever are really thinking of these irrevocable trusts as so restrictive and something annoying that I have to deal with. And I try and sort of position it, hopefully before even the grantors have passed away, as something like, how cool is this? You hit someone with your car and you get sued. No one can touch this. You go through a bad divorce. This can't be subject to the divorce judgment. This is like amazing asset protection that you can't, at least in California, we don't allow self-settled trusts. So I can't set up an irrevocable trust in California and say, oh, I want to be the beneficiary of it and put my assets into it and have creditor protection. We don't allow that. So this is like a very unique opportunity to get this protection. Do you really want to give it up? So see what they're looking at that point. So I talked about the court modification as sort of being, again, sort of once you've exhausted all the other potential opportunities to modify without a court order, it is something that, again, most judges are very understanding of, especially, again, if all beneficiaries are consenting to this modification and that the trust is really just not necessary to carry out this material purposes. Again, it started to whittle down. The big one is obviously you're arguing changed circumstances that the grantors couldn't have or wouldn't have anticipated at the time they drafted it. And it gets to be a little bit, again, you look at the idea that if there's a minor beneficiary, they may need to have a guardian ad litem appointed through the court process. And it's, at least in LA County, a little inconsistent on when the judge might require that, but know that it could come up as part of the process. And that's sort of, again, an additional expense to the trust to modify it. But obviously, it's to ensure that a minor beneficiary's interests are protected. But again, I don't see that consistently applied across the board in these petitions. You kind of wonder when you're modifying it by an agreement or through this court process, how far down the line is someone impacted or affected by it? So we usually know, okay, there's generation one, settlor set up the trust. Children are usually the ones oftentimes towards the end of their life ready to modify or change this, looking at their kids consenting, and then we kind of stop there. But you have to think far of how, who's entitled to notice, who would be entitled or required to consent to this, because it kind of start to go down a bit of a rabbit hole there. So we've already talked a little bit about the AB trust or types of trust that are triggered when one spouse passes away. And ultimately, this is a really important part of sitting down when you're establishing the estate plan and really discussing with the married couple, what are your goals and objectives? When you look at what happens when one spouse passes away, ultimately, you're looking at, you know, do I want more protection for my kids? Do I want more flexibility for my spouse? Am I worried about taxes? You really sort of have to counsel the client to determine what is their goal and objective, and how do we create the trust to ensure we're accomplishing that. And at the end of the day, that might mean that we need to build in certain provisions of the trust that might be unique, but we need to be aware of what those goals are first before we can design or craft a trust that works around it. So the estate marital deduction, and again, I think Larry was mentioning that in 1983, but it essentially is allowing between married couples unlimited amounts that can pass. So I can have a $10 billion estate with a B, pass away and give that all to my spouse and there not be a tax triggered. I can give it to them outright, or I can give it to them through a general power of appointment trust where they can do what they want with it when they pass away, and say through a general power of appointment where it goes, and I'll go through in detail what that is, or a Q-tip trust. Okay, and I never liked this name, Qualified Terminal Interest Property Trust, but hey, it was coined by Congress, so it gives you a hint where it's coming from, but it was made up by them, essentially, codified by Congress, but it's a law by Congress. And now for you to qualify for the unlimited marital deduction with this property going to trust, it needs to either be, again, a general power appointment trust or a Q-tip trust. So we'll talk about all three. So the general power appointment trust versus the Q-tip, both require income to the surviving spouse for the lifetime. That is what it needs, one of the terms it must comply with in order to qualify for this unlimited marital deduction. But they differ in the ultimate disposition, as it mentions on the slide. A general power of appointment, where the spouse can do pretty much upon their death, give it to anyone they want, or during their life. So it could be during a lifetime power of appointment or testamentary at death. So very broad. So again, you probably wouldn't use this, for example, in a blended family situation. You'd be looking at, I want to say if I passed away and my assets go into a trust for the surviving spouse, I may not want them to be able to just do what they want with it. So I'd prefer, and under the Q-tip trust, the law does not require the spouse to have any control at his or her death. So it doesn't usually have a power of appointment, or if they do, it might be limited to something like, okay, it has to go amongst my descendants, but not, to someone else like your new spouse, your new boyfriend or girlfriend. And I think when I described these two approaches, it's again about, I tell my clients, it's not that you don't trust your spouse. It's essentially what gives you the peace of mind, knowing I passed away, these terms are locked in, versus I want to give max flexibility to my surviving spouse to do whatever they want. Okay. Now it gets a little bit more complicated when you have non-U.S. citizen spouses, because there is no unlimited marital deduction. So between married couples where they're both not U.S. citizens, that unlimited marital deduction does not apply. So if they're U.S. persons, they get the 13 million exemption, but that's their limit, which may not be an issue for a lot of people, but you need to bring it up. Your questionnaire for your estate planning clients should look at, have a box to discuss if they're both U.S. citizens, because if there is going to be a taxable estate, you want the share set aside for the surviving spouse above and beyond that exemption of 13 million to go into a qualified domestic trust, or a QDOT, which has all the same requirements of the marital deduction trust, but it has to have a third party additional trustee that is a U.S. person to be a co-trustee, at least with that spouse. So these outright gifts to the surviving spouse, you can use your estate tax exemption for, but they don't have an unlimited marital deduction. And sometimes when clients are putting off becoming a citizen just because they're kind of being lazy about it, this discussion about, well, okay, if your estate is over the exemption, you're gonna have to deal with this QDOT, someone else may have to be the trustee, and it gets complicated and they don't like it, it kind of pushes them to go ahead and get their citizenship, just because they've been putting it off. So, again, an important discussion to have with them. Another type of irrevocable trust, and I'll actually be talking about these types of trust again later on today, so you'll hear about it again. These are all advanced planning techniques. So these are not stuff that, you're going to walk away knowing, oh, I completely understand and know how to do it. I think our job is to make sure you can issue spot and identify cases in which you think this might be appropriate. And then likely if you were just kind of getting started and getting into this area of law, you'd want to co-counsel on with a more experienced attorney or planner on anything like a charitable trust, for example, or any kind of irrevocable trust, because it's just definitely more complex. So we call CRTs, charitable remainder trust, and some other trusts that we'll talk about today, split interest trusts, because they are trusts where there is two types of beneficiaries' interest, the charitable and individual beneficiaries. So, and there's more than two, but two kind of basic types of charitable trust. The charitable lead trust, where the charitable interest comes first. They get income coming out from that trust for the settlor's grantor's lifetime. And then an individual beneficiary follows with the remainder after the grantor passes away. The residual goes, often back to the kids or the family member, versus charitable remainder trust, where the grantor, the donor, is getting all that income during their life. And then the charity follows upon their passing, their lifetime interest expires, either after a period of time or when they expire, and then the charity gets the residual. And these work really well for cases where a client is selling a highly appreciated asset. They have a piece of real estate they've been sitting on for a long time. Maybe they're tired of managing it and they just want to put it in stock or income generating investments, live off the income, and they don't want to deal with management of it. But they also don't want to pay a ton of capital gains tax when they sell it. They can essentially gift into this irrevocable trust that has a charitable remainder interest, while they can live off the income during their lifetime. Works obviously very well if they have a charitable intent, because ultimately you're going to, be hard pressed to say a good portion of that gift or their estate is going to go to a charity if they're really not interested in that. So the annual payout from, let's say, a charitable lead trust, where the charity has the initial interest for a term of years or lifespan, they get a fixed amount, or it could be actually a percentage of the trust assets. And looking at which makes sense might be important to say, okay, if they get a fixed amount, but the asset I'm putting into the trust isn't generating income right away until it's sold, you might want to have something that can flip from a fixed amount to then a percentage later on. And a lot of the times when I'm working on something like creating what this structure would look like, I'm working in tandem with like the financial advisor to figure out the investments and what would be that fixed amount or percentage, and running a few scenarios to make sure it makes sense and it complies with the different rules and regulations. We'll talk about grantor and non-grantor trust actually in the next session. So you'll essentially want to kind of hold that thought, but the charitable lead trust can be either. And at the end of the term, it can revert back to the donor or other individuals, depending if they want the asset or not. And then the charitable remainder trust, as I mentioned, ultimately is the opposite, where the fixed amount is paid out to the individual donor at the time while they're alive for a fixed amount of term of years. And then on their passing or the end of the term, whatever's left is going to pass to the charity of their choice. It has some restrictions. You have to at least pay out 5% annually and no more than 50%. And then here's the kicker, the last one at the end. Because sometimes these look very attractive to the client until they understand, look, there needs to be something left for the charity at the end. The IRS requires us to run an illustration and essentially be able to say that the remainder interest, whatever the charity is getting, must be worth at least 10% of that initial contribution. So that's important to look at as well, too, or the client to really understand. Because that might mean you need to adjust the percent payout means the client might need to adjust how much they're going to get out of this and get a little bit less. So again, a very case specific thing, but good to know a couple of the differences between the two besides the obvious that we mentioned earlier. You can add to charitable remainder unit trust, and that has a different way of calculating the annual amount coming out, but you can't add additional assets to the charitable remainder annuity trust. The charitable remainder uni trust, or CRUD, has basically a choice between the lesser of the percentage payout or net income. So it gives us a nice flexibility, and also allows us in some cases to play a catch up in a calendar year if there's a lot of income in one and too much, but not in the next year. We can take the income from the last year and now pay it out. So again, got to look at a lot of these different nuances. So that makeup provision in the future may be very useful to the client, depending on the type of asset that is initially transferred into that trust. So looking at the investments or the type of assets and income generated is really where I lean on the financial advisor to try to decide which one makes the most sense. Really, the most appealing aspect of a CRT for the client is that they don't pay, and they defer capital gains with CRT. They don't pay income tax at the trust level. Okay. The CRT income is distributed to the individual beneficiaries either as ordinary income, that's initial tier, capital gain, tax-free interest, and the return of capital. So again, this goes to really the purpose behind looking at this for a client would be highly appreciated assets are transferred to the CRT, sold by the CRT, and the full proceeds are reinvested because, again, they are a charitable contribution. So what I think gets the client at the end of the day is when the income starts pouring out, they do need to pay income tax on that. Right? That is income. I'll try and go, well, I don't want the income. Okay, we'll turn around and donate to a charity and get a deduction for that. So ultimately, again, prepare the client for that additional consequence. And maybe in that case, it was better for the client to do a charitable lead trust where the charity is getting that income. I don't know, but it really getting down to really talking to your client at the outset of this. Okay, sounds great that I don't have to pay capital gains tax on the sale of this asset, but ultimately, at the end of the day, there's going to be income coming out of this. Do I want that income? I'm okay paying tax on it. And if it's a large asset, it'd be a lot of income tax. I had a client who was really upset about this. I don't want the income. And you know what? At the end of the day, he figured out how to spend it. So, he was okay. Some other planning considerations. Who will the beneficiaries be? Sometimes it's a donor and the donor spouse, so that they worried, making sure their spouse would be able to continue to get that income. Really make sure you're running that 10% remainder test and determining the percentage payout, because at the end of the day, it won't count if it doesn't meet that test. So you really need a program, honestly, like Numbers Cruncher or something like that would run that test to make sure it passes that. Most clients want to retain the right to change charitable beneficiaries, and I think that's great. And then the last point is bolded, and I think for good reason. Ultimately, you have to tell the client these are not no takebacks, right? This is irrevocable transfer into the trust. You're going to lose. In many cases, they can be the trustees, so they like that. But a lot of times they don't want to be because they have to deal with the tax returns for the trust, and they don't want to deal with the administrative burden of it. But you can just unwind it and say you want it back. And when you're dealing with charitable gifts and bequests, you also need to follow the terms of the trust, because if you don't, guess who oversees these things? You got the Attorney General's office looking at charitable bequests and things like that. You have the IRS. So these are, again, serious considerations before they make this transfer. And like I said, it's a really not necessarily a great fit for someone who's just doing it to try and get the income tax write-off. it's really better if they do have some donative charitable intent before even initiating this conversation. Otherwise, it just really doesn't make sense. Okay, so this is something that, again, gets a little bit more complex and nuanced, but ultimately it's coming up quite a bit. Because at the end of the day, a lot of clients are locking in their estate tax exemption by giving away a piece of property or an asset into an irrevocable trust for the kids. And the type of irrevocable trust oftentimes is an intentionally defective grantor trust. And we'll talk more about the grantor trust, where essentially the definition of that is the income is taxed to the grantor, the person who gave the gift. So when we talk about intentionally defective trust, it's deliberately designed to be a grantor trust. Even though I gave away this asset, it's my kids now, I'm still paying income tax on it. And so that sounds very counterintuitive to the client till they understand that those income tax payments are like freebies, additional gifts to allow the irrevocable tax-free bucket to grow while they're reducing their size of the estate through the tax payments. So like I said, it sounds initially very counterintuitive, but by far, this is one of the best mechanisms to reduce the taxable estate. So you want to have, again, a pretty large estate because you're giving away this asset. The income's not yours anymore, but you're still paying the income tax on it. And in order to accomplish this goal, there are certain provisions that need to be in the trust, but the grantor retains certain rights to do certain things. And I'll explain what those are in a second. So the grantor is, we talked about this already, almost making like a non-taxable gift to the beneficiaries of the trust by making these income tax payments. Another type of IRA trust or a type of irrevocable trust you might find are IRA trusts. And just so you know, if a beneficiary of an inherited IRA is not what we call a designated beneficiary, these are kind of basic IRA rules you should be aware of, then the account must be paid out by the 5th year anniversary of the date the death occurs. You've got that 5-year rule. And as we know, IRAs are subject to ordinary income tax when you pull it out, so they got to pay that tax on it. So oftentimes people are interested in how long can they stretch out those required minimum distributions. And so ultimately we're looking at how do I ensure that this is paying out to a designated beneficiary to stretch it out for longer. Certain things are clearly not just by law designated beneficiaries. Charities, they don't get the stretch out rules, but they also don't pay income taxes. Probate estate and a lot of trusts don't qualify as a designated beneficiary unless they're very carefully drafted. And so if you make a trust the beneficiary without making sure that the trust is a qualified designated beneficiary, you might trigger it accidentally, this 5-year rule, and have the beneficiaries have to take the money out a lot faster, unfortunately. So instead, the stress treatment of an inherited IRA or 401k means spreading out the distribution of the life expectancy of the beneficiary. And it was really great before the Secure Act. You could do that over a broad range and over a lifespan. But now, under the Secure Act, only those eligible designated beneficiaries can do that life stretch out. Everyone else withdraws after 10 years of the December 1st of the year following the death. So December 31st. So you got 10 years to pull it out and pay the tax. At least not 5, but 10. And there are a few exceptions to the 10-year rule, and those are surviving spouses. They can still do the stretch. They can still do a spousal rollover and stretch it out over their lifetime. If the children of the participant are minors still or under 26 and in like an improved educational institution, a disabled beneficiary, chronically ill beneficiary, beneficiaries that are not more than 10 years younger than the participant. So these individuals in this list are eligible designated beneficiaries, and they can actually stretch it out over their lifetime. So they have a nice exception to that. So how do you find out if the trust will qualify as a beneficiary for an IRA? And that's one of the questions that just came up. I'm going to answer it right here. The trust needs to be a a conduit type trust or a designated beneficiary trust. So trusts can be treated as designated beneficiaries if they have or qualify under the IRS rules. And those essentially are irrevocable trusts. They cannot have charities as beneficiaries. They're designed to have a single beneficiary receive all the minimum required beneficiaries, required minimum distributions. Individuals and not charities, okay? Then that beneficiary, rather than the trust, will be the designated beneficiary. So think of it as what we call a see-through or look-through trust. So even though the payout will be made through the trustee initially, it will then result in each beneficiary, the separate individual beneficiaries, being able to set up inherited IRAs and stretch it out over the 10-year rule. Okay. So, you know, if you have a minor beneficiary, this is a good idea, right? To be able to pay through the trust, have the trust qualify as a look-through or see-through as a conduit trust, and essentially then be able to stretch out the withdrawals over a period of time, okay? So you just have to comply with those rules in order for it to ensure that it qualifies as a look-through or see-through trust. Another type of irrevocable trust is a qualified personal residence trust, another fairly complex strategy that is used to remove the house out of the taxable estate. And it's another type of grantor trust where the grantor retains a certain right to reside in the house, but again, the underlying asset has been gifted in part, which is like not a complete gift yet, because the grantor has reserved the right to reside there for a period of time. And that allows us to discount that initial gift or transfer because it's subject to this right to reside. So it's not worth as much. So it's a great way to pass on a very, expensive or highly appreciated residence or vacation home by discounting the value of that gift because they they kept the right to reside there for that period of term. They need to outlive that period for the gift to be fully vested and now go to the next generation, or i.e. the children. But ultimately, at that point in California, that will be a change in ownership and the property taxes will go up. So once Prop 19 passed in California, it really made the QPERTs a little less attractive because at some point, we all know the property taxes will go up. But, we want to defer that as long as possible. But at the end of that term, it will trigger reassessment. But again, it might have gotten a $30 million house out of the estate. Okay. The cost basis doesn't reset because you trade one for the other. At the end of the day, if you are not paying estate tax on something, that's great, but you don't get for that lifetime gift, you don't get that new basis in that highly appreciated home. So again, you have to weigh the estate tax against the capital gains tax. And I guess if you had to pick one to pay, I think it would be the capital gains tax, right? Because the rate is 20% versus almost 40%. But you have to understand that there is a give and a take, a pro and a con. And I already went over generation skipping transfer tax, so I have to cover this in the next minute or so. But it's an additional tax that essentially, as I explained earlier, they made up when they realized lawyers were creating creative ways of these ongoing trusts that were not includable in someone's taxable estate for estate tax purposes, but they wanted to hit them with this GST tax. And it would be triggered if I make a direct gift to a grandchild from a parent, or another a taxable termination of, let's say, I put it in trust for my child, then they pass away, then it's going to a skip person, the next generation. So they're going to pay the GST tax upon the termination of that child's interest going into generation 3, the grandchild's interest. But of course, we do get exemption that we can apply to that type of trust. On top of the estate tax exemption, we can apply a GST exemption, so you can make that trust GST exempt. But what if the trust is bigger than that 13 million exemption? I mean, it used to be a million in 1986, but it's 2023, 13 million now. So at the end of the day, this is great. This is a great idea and very helpful. to then apply to those gifts that would normally be subject to the GST. But let's say the estate is larger. Let's say I have a $30 million estate. I can apply my estate tax exemption, 13 million, my GST exemption, 13 million. But that excess will be held typically in a non-GST exempt trust. So that's the trust you'd want to tell the kids, if you got money that you need to pull out to pay expenses after I die, use that non-exempt trust. So you want to track what's in the non-exempt trust and use that while you're alive, and most likely design that to be includable in their taxable estate, and therefore get the step up, because it's going to be subject to this GST tax anyway, right? And then shelter and hold on to and don't spend out of the non-exempt share. So it gets a little bit complicated to administer these large trusts, because you'll have an exempt, a GST exempt, and a GST non-exempt share if the estate is so large. Fun stuff. Dynasty trusts are, as I've been mentioning, these irrevocable trusts that you would set up at the end of the day to keep going on for multiple generations, exclude those assets from the taxable estate, and oftentimes be GST exempt. But again, in California, we have the rule against perpetuities. So you just kind of design it to last for the maximum of that rule, or set it up in a state that's abolished it if they're looking at that kind of wealth transfer. But then at that point, because you're looking down the road way in the future, please allow for flexibility in that trust by appointing, again, a trust protector, or the ability to appoint later on a special trustee who can make modifications to the trust if circumstances change. So a intentionally defective grantor trust that I mentioned earlier can be designed to be a dynasty trust. It can be designed to last for one generation, and then they got to pay the tax the next generation. Or you can kind of do it better, I think, and say, well, let's have this IDGIT, this intentionally defective grantor trust, go on for multiple generations in the form of a dynasty trust. When you're looking at doing that gift and locking in the exemption, you can do it for multiple generations in the form of dynasty trust, again, as long as it doesn't violate the rule against perpetuities, and make sure the GST exemption is applied to that trust, so it can also be exempt from that tax as well, too. There are other types of tax efficient trusts that we probably won't get into today, but these are, split interest trusts where I can essentially put an asset in a grant or retained annuity trust where I get an annuity payout from the income generated from the asset I've gifted in there. But at the end of this annuity period, that asset goes to my kids. So I get it out of my estate very effectively that way. So it's a good for, I have a client, give you an example, who company went public, the stock went down, but we expect it's going to go back up again. So they'll definitely outpace the annuity payout that's required in order for it to hit that limit, and essentially pay out to him this X number of dollars out of the trust. So some of that money will come back to him and back in his taxable estate, but then we hope it's going to appreciate much more than that. So this will grow to a much larger trust that eventually will distribute it to the kids. So that growth over the annuity payout is now outside of his taxable estate. And the best one I had, it was $65 million, where that fixed amount for a period of time went to the grantor. But these were all like these, private investments and very speculative types of investments that just did really well. And after that period of time, about $65 million got out of the estate tax-free. So it was very, very cool. Lots of types of irrevocable trust have a demand rate, so they can qualify for the annual gift amount. So I might put $1 million in a trust, but in 2024, that annual gift amount of 18 can be subtracted to that gift if it has what we call crummy withdrawal rights. So that you may want to incorporate that into the terms of an irrevocable trust. It requires to have the special language that they're able to withdraw money from the trust, but no one actually does it. They just need to be notified they can do it, but ultimately leave the money in there because it'll pass to them tax-free. But they do need to have this withdrawal right for it to qualify for the annual gift amount. And then donors can, make use of full of their annual exclusion by other ways, by just gifting into a trust, or, for example, just gifting outright to someone as well. So they can, or just so you know, gifts to financial to universities or educational institutions, or gifts for medical expenses are not subject to any limits. Another way to get a lot of money out. You want to look at, making sure before you transfer to an irrevocable trust, whether it's taking stock that's going to lose S election if you put it in there. Residents, how to ensure to be able to pay taxes if I put them assets into a QPERT or residence trust. How do the cost of living expenses and things like that go into that. Life insurance trust that holds life insurance that ultimately ensures that the payout of the death benefit is not subject to is not subject to estate taxes. Lots of cool irrevocable planning. Tax law is going to change, so we need to look at what are ways to be able to have flexibility built in, and maybe create some ways to build in that flexibility, changes in the tax law. Checking in with your clients. I know this came up in the last. I do it every 3 years automatically. They're just on a system that they get a note. And I'm a little anal about keeping an inventory of assets in the estate because it's very helpful in the trust administration phase. So ultimately, I will, require them to come. I'll bug them to come back every 3 years to look at the very least this inventory so I can keep that up to date. Because the tax law will change. I mean, there's not a lot that moves very quickly in this area of law, but it's enough. You might want to give, I like this point, giving the attorney in fact power of attorney to amend a trust if you don't incorporate a trust protector or trust advisor. Have alternate trustees empowered to remove successors. And I mentioned a special trustee that can also change the terms of the trust. So before you start drafting irrevocable trust, I think that's really important to start looking at what ways to build in flexibility. There was a question about how the tax exemptions on the personal residence applies in a QPERT, I'm assuming is the question related to. So at the end of a term of a QPERT, the property tax gets reassessed unless an exemption applies. And there still is a parent-child exclusion, obviously, past, post Prop 19. It's just limited, right? So one of the kids would have to move into the house for that to qualify. And while a parent is living there, they may not want to do that. So they could try to apply for that exemption, but oftentimes at the end of that period, term where the term of the QPERT expires, the parent's still living there. So it just may not be practical to expect a child to move in to the house as well too, right? The parent may not want that, but I suppose technically the client could and try and qualify for the parent-child exclusion. I don't think there's other questions, Kelly, but I think we could start going on to the next topic.
Yes, I don't see any. Oh, I have one more question here. I'll
sure.
copy and paste that. And then what we'll do is we'll take a quick 10-minute break.
Okay, great. When a client funds a trust, is a gift return required to be filed if the transfer? Yes, very important. And I think, this is all, again, advanced planning. So what I do is a memo to the client saying, okay, now you've set up the trust. It's usually a pretty, extensive process deciding how much to gift to and to what to gift, get valuations for everything. So let them know they need to get a valuation for the assets going in. And oftentimes that's part of the process. So we can figure how much can we gift. And then the next year when they go to file their personal return, their CPA, or sometimes we do it, needs to file a gift tax return to report the gift. And that's where those valuations get attached. And gift tax returns, really, if you think about it, the only thing the IRS would audit, because oftentimes there's no tax due on the return because they're using their exemption. But you want to make sure the IRS is in line with what we're arguing the value is, because when we're gifting fractional interest of things, it's a very, very cool strategy or ability to argue a discount valuation. If I'm only giving, like I mentioned at the QPERT, a house, but reserving some rights, or if I'm giving only 49% of a business or a piece of real estate, the IRS allows us to apply a discount of up to, I've seen as high as 38, 39, definitely a 3% interest, especially if an asset is held, like a piece of real estate held in an LLC, or we can tie up voting restrictions and rights. It's not marketable. So they need to get that valuation. We usually argue a discount and use that valuation to file a gift tax return next year. It's great. All right, we're going to get started here. Some of this will be a nice kind of review of a few of the concepts that we covered in the last discussion. So, and then I just noticed I'm covering charitable remainder, charitable trust again later this afternoon. So some of the concepts that were pretty dense in the prior session get covered again, which is great. So it can regroup and ask any other questions you have on that. So we learned in the last section that grantor trusts, or the income is taxed to the living grantor. They can be revocable or irrevocable trusts, and they could be, as you mentioned the last night, irrevocable, like an intentionally defective grantor trust, which is an irrevocable trust where someone's giving away an asset, yet they are still on the hook for paying the income tax. All revocable trusts across the board are really grantor trusts with income principal included in the grantor's estate, and they pay taxes. As I think Larry covered earlier, you're not filing a separate tax returns or anything like that. If it's an irrevocable trust, even if it's a grantor trust where the grantor is paying the income tax, you typically see the CPA still file an informational only return where they'll say, hey, here's the return for the trust, IRS. I know you're kind of expecting it because it's irrevocable trust, but see grantor's personal return, and look, the IRS doesn't really care as long as someone's paying the income tax. I wanted to cover again crummy withdrawal rights. If you're making a trust to a gift where the beneficiary, it's an irrevocable trust, the beneficiary has this right to withdraw part of the gift that you give, it qualifies for the annual gift amount of the $18,000. So if I give $1 million, an example I used earlier, if I give $1 million gift to a trust, and I have my 4 children as beneficiaries, and it has a crummy withdrawal right, it means it allows them to withdraw part of that gift. They essentially are going to do that because it wouldn't benefit them, but I get to subtract from that gift 18,000 times 4. So it reduces the amount of the gift I need to report to the IRS. So sometimes it's really good to include those. You'll want to look at internal the IRC code section 671 and 679 to talks a lot about grantor trusts and how to ensure that you can properly draft an intentionally defective grantor trust. And essentially the ways you're doing it, or the powers that the grantor retains during their lifetime, allows them to ensure that it's defective for income tax purposes, but still not includable in their taxable estate. So it's outside of their estate for estate tax purposes. And so this ensures that you're including certain provisions that allow them to do certain things, but making sure not to include provisions that include a bit in their taxable estate. There's no step of and basis for assets. So when you're going through with a client, the idea that you're giving this gift and it's going to take the assets outside of a taxable estate. As I mentioned in the prior session, the beneficiaries, they're giving up one tax for the other. They do not get a step of and basis. They will have to pay capital gains tax if it's sold because they're carrying over the basis of the grantor or the donor. But again, when we're comparing capital gains tax to estate tax, the rates are different. And there's other things available to them if they want. If it's real estate and they want to do a 1031 exchange, they can. So it's still usually in a large estate makes still sense to do it. But, you know, again, maybe putting into this irrevocable trust legacy assets that they think they're not going to sell. What are some retained powers that fail to create a grantor trust? Deferring income of less than % the trust value, exercising it only by will, being able to allocate amongst charities, distributing income and principal to named beneficiaries. These are all things that are retained powers that fail to create a grantor trust. So ultimately, if you want those type of provisions in there, then it's not going to create that grantor trust. There are several types of grantor retained interest trust. And we saw these also discussed in the prior session as well too. The Q-tip trusts are grantor retained interest trusts. and the personal residence trust, where it removes the real estate from the grantor's gross estate with retaining some right to reside there during that period of time. Qualified terminal interest property deduction trust with Q-tip trust, you have the right to income. The spouse has the right to income in principal during their lifetime, so they have that retained right, and then it passes to the beneficiaries upon their death. We also already talked about the charitable remainder interest trust, and the grantor is going to keep some income during their lifetime, and the remainder goes to. And these are all what we mentioned earlier, split interest trusts as well, because there are two beneficiaries with interest at different times. Going to a little bit, again, recapping a little bit on the qualified terminal interest trust is assigned to the surviving spouse. They get to take advantage of the marital deduction, as I mentioned earlier, so there would be assurances of no tax at the first spouse's death. The property tax, property is not includable in the surviving spouse's estate. For estate tax purposes, it's great. May not be so great for the surviving spouse's heirs. So ultimately, sometimes it's better to fund the bypass trust. And ultimately, a Clayton election type trust allows the surviving spouse to toggle and decide whether it makes more sense to fund the bypass trust, so it's not includable in their taxable estate, or a Q-tip trust where it is includable in their taxable estate. Still limited to what they can change as far as beneficiaries, because it's an irrevocable trust. And depending on whether you get a step up in basis or not, right? The bypass trust doesn't get you a step up in basis, but a marital trust does. So the Clayton election allows us to decide which of those two to fund at first death. It may make a lot of sense to have that flexibility. Grantor's lifetime income or unit trust payment. These are the types of retained interests that you might have in a grantor trust. They are able to assign retirement accounts to charities. And so one of the benefits of looking at, for example, perhaps creating a testamentary charitable trust or charitable remainder trust upon your death is you can assign actual retirement funds to that charitable remainder trust. And so the kids will get that charitable deduction, but get some income from that at a longer rate than they would at the 10-year rule. So it's kind of a unique, I haven't seen a lot of clients use it yet. I think it's a great idea, but how this works is, again, you're saying, okay, upon my death, I'm going to make my trust the beneficiary of my retirement plans. You get a charitable deduction, so that's great. You say this is a testamentary charitable remainder trust, so it only comes up upon my death. The retirement funds funnel in through there. It has a annuity payout to the children during their lifetime over a longer period of time than just that 10-year rule, right? And then at the end of the day, whatever's left after the kids have passed away does go to charity. I think it's a great idea. Like I said, I haven't had someone with enough of a charitable intent and a forward kind of makes you kind of look really far into the future with something a little bit more complex to administer, I suppose, as well at death. I haven't seen someone take advantage of this yet, but I think it's a great idea since the Secure Act really limited how long you can stretch it out. So taxable retirement accounts make a lot of sense to actually go into like a testamentary charitable remainder trust. And again, the remainder goes to a charity and it doesn't need to pay income on the tax of that corpus. So that's great. There's also good retirement planning that doesn't involve a trust. It's a little bit simpler if the client either doesn't have kids or the kids have enough assets. I think at the end of the day, one really easy and simple solution would be just simply name a charity as the beneficiary of a retirement plan. If you have a client who's incorporating charities into their planning, it may be a good idea to just essentially leave them out of the trust and just put them as direct beneficiaries on the retirement plans and make it really, really easy and simple. And I think people often overlook that as a really nice solution to incorporating charities in their estate plan without having to drag them in the trust, provide accountings to the charity along the trust lines, and add additional beneficiaries or complexity to that trust administration, just make them direct beneficiaries of the IRAs. So a very nice option, and that does mean it's going direct. So unlike the charitable remainder trust, the kids aren't getting any lifetime income from that IRA, but they again might be getting enough other assets. When you're looking at what to put into these grantor trusts, you obviously need to actually transfer the assets to make that a complete gift or to make it an effective transfer. We covered with Larry a lot of the funding issues that we see. Real estate's the easier one, where you need to see a deed transfer to the trustee of the trust. And ultimately, you have to be careful about causing reassessment for capital gains tax, for property tax issues. So if I'm gifting a piece of real estate into an irrevocable trust, grantor or non-grantor trust, it could be a change in ownership that I need to that the assessor's office is going to ask for a copy of the trust. They're going to look through that trust and say, okay, if it's a grantor trust, a marital trust, no problem, surviving spouse, no reassessment. If it's intentionally defective grantor trust to be a completed gift to the kids, ultimately, then that could trigger reassessment unless the principal residence exclusion applies. So you have to be careful with those transfers, but you can transfer cars, boats, and other things as well too. And oftentimes when we're looking at real estate to transfer into an irrevocable trust, we're looking at likely wrapping it in an LLC, because with the rules with LLCs are different. You can transfer 50%, up to 50% of an interest in an LLC, real estate held in an LLC, and not trigger reassessment. So sometimes there are creative ways to still make a gift outside of the taxable, move the assets outside of the taxable estate. You get a discount valuation for the gift, as I mentioned earlier, because it's a fractional interest, and not trigger reassessment. So great strategy. But the real estate does need to be held in an LLC to utilize that strategy. You are funding the grantor trust through a transfer of stocks or bonds, a personal property assignment, an LLC assignment, but be careful not to lose subchapter S standings. So I had to go through that rather quickly at the last end of the last section, but to revisit it now, if you transfer into an S corporation to a trust, it needs to have certain provisions or make certain elections. And so it's important to look at that with the CPA at that time. And if you are making retirement funds, the trust, the beneficiary of a retirement fund, then again, you need that see-through or look-through language to make sure they can stretch out the withdrawals over a longer period of time. We're trying to preserve flexibility and change. So this is a little bit of, again, a repeat of the prior presentation where we talked about how do we build in this flexibility. I mentioned trust protectors, which is recently codified in California law, been around for a lot longer. They can change the place of administration, the state of administration. They can change trustees. They can even change withdrawal rights for a beneficiary if circumstances change. So it allows the ability for us to change the terms of the trust when after the grantor has passed away, and using other things like decanting as well too. Oftentimes, a trust protector can decant the trust. I believe in the material you've been provided some nice samples of a lot of these different types of trusts that you can take a look at over, in your spare time, and provide sample language. Other types of, sample trusts that are included in the materials is a third-party special needs trust, and that's designed for someone who sets up a special needs trust for a family member that has a disability, and they are able to leave assets to that family member with a disability and preserve any government benefits they have. And ultimately, at the end of the day, most of those third-party special needs trusts can be drafted without a payback provisions, meaning I can leave an adult child with disability whatever I want if it's held in a third-party special needs trust, where at that point, a third-party trustee is doling out the money on their behalf. they're not just getting money in their own hand. It has some restrictive provisions. I typically don't see them drafted with payback provisions because you don't need to. Contrast that to a first-party special needs trust. So if, for example, the person with disability is receiving a settlement, and med malpractice settlement or something like that, and they're getting the money, and then they'll need to set up a first-party special needs trust that will likely have payback provisions in it. Other types of irrevocable trusts that you'll see, and we talked a little bit really briefly, you saw in the other slide, a life insurance trust. But in California, just kind of something new and good to be aware of, our version Medicaid was Medi-Cal. It is not needs-based. Okay, it's as of this year, you can have, there's no asset limitation. It is income-based, so if you have a bunch of income from your assets, it's going to affect the share of cost up to a point where your share of cost is equal to the benefits, so you're not going to have a benefit. But house was always a big thing. Okay, I have a house, and what if I sell the house and move into a nursing home? Then I'm going to have too much assets. So people will used to put residents into an irrevocable trust, and sometimes it's still a good idea. It's really on a case-by-case basis. And ultimately, they're also worried about the recovery for the payments that are paid out over time. And so holding a house in a trust is still a good idea if you're on Medi-Cal. But again, not as necessary when we're looking at income asset-based issues, but sometimes necessary when we look at income-based issues. And I don't do Medi-Cal planning. So again, usually looking for an elder law attorney to really focus in or hone on the issues that arise in that context. But really, I think walking away from this today, knowing that Medi-Cal is not asset-based is an important point. An irrevocable life insurance trust is a really great mechanism to have all of this nice death benefit. No one likes paying the estate tax, the premium on a life insurance policy, but when it pays out, it ultimately is very helpful. It's cash, it's fast, but unless it's held in the life insurance trust, the asset, it is includable in their taxable estate for estate tax purposes. So wrapping it into a life insurance trust that has crummy provisions that allow the annual exclusion to be counted against the premium payments and not having to report a gift every time the premium is made is very valuable. So life insurance trust, if a client's getting a large, insurance policy, really want to look at whether it should be held in a trust like this. So we talked about how typically the grantor pays income on a grantor trust on their return. So I suppose, again, technically no trust tax return, which is a 1041, is required when the grantor and trustee are the same person. Sometimes I've seen a CPA still do it as an informational only return. But typically we tend to still get the separate tax identification number because you're going to need it at some point anyway when the grantor dies. So this is nice to have it already and set up and going. And I would defer to CPA whether they want to file that separate return if the grantor and the trustee are the same. I typically stay away from having the grantor and the trustee be the same person when it is a trust that we're trying to remove the asset from their taxable estate. Because you start to get worried that they're creating too much control over the assets. If the asset in the trust is not generating enough income exceeding the below $600 each year, they don't need to file a return. That's the limit. And then if it's above, then of course the irrevocable trust does file that 1041 and issue K1s to the beneficiaries for the income that's been distributed. Or of course, if it's not distributed and it stays at the trust level, the trust just pays it, right? But you look at, there are differing rates for individuals and trusts. So you want to look at whether it makes more sense. Trustees need to be in a grantor trust with the power to make interfamily gifts if you want that flexibility. So here's some kind of drafting tips or terms that you want to consider perhaps including in a grantor trust. You'll see oftentimes the term that allows the grantor or beneficiary to borrow money from the trust with inadequate security without having to pledge or repay the trust back. But oftentimes it's more of a power that's in there to make it a grantor trust, not necessarily one that someone uses. You'll see, general powers as being able to vote and on corporate stock and continue to control trust fund investments if that's important. We talked about this in the liar slide, that you need to file a 1041 for these types of trusts. And if you're distributing net income, then the beneficiaries will get a K1, attach that to their personal return, and pay for the income on their personal return. If it's distributed income, then of course, yes, they're going to get a K1. There's a natural ability to terminate a trust if the value falls under a certain limit. We saw that in the first session with the first session I did with the probate code allowing that. And the trustee can prove that continuation is not economical, and perhaps again having a trust protector having the ability to do that. Okay, so if there are any questions on this one, I don't see any. If there aren't, then what I can do is go back to a couple sections, because we covered this one in a little bit less time than I thought. And I think Kelly was having a bit of technical difficulties, so I don't know if she's able to monitor.
I think I might be back. Can you hear me okay?
She's here. So what are common mistakes that attorneys make in drafting grantor trusts? The ones that I see the most often would be probably not allowing for flexibility. And obviously, again, kind of looking at, well, what makes an irrevocable trust a grantor trust, and making sure it's, again, the power to substitute assets, the power to lend with inadequate securities, without adequate security, the power to substitute, lend with add charities to the trust, power to substitute assets in and out of the trust. Those are kind of the key ones that we make it a grantor trust. So obviously you need to include those. If you don't, then it's not a grantor trust. But beyond that, I think the other thing is, if you are going to make the grantor of that, also the trustee, I think then honestly, I see a lot of mistakes with including too many authority or powers the trustee can have, which is why generally I just don't advise it. Say, if you're going to give this asset away, then you give it away. At that point, let your kids be the trustee of that trust, or at the very least, maybe do 2 intentionally defective grantor trusts, and I guess your spouse could be the trustee of yours and yours of theirs. Still don't love that, because again, you have to be pretty careful in drafting. I see some errors with that will then cause estate tax inclusion, and will require the asset to be pulled, or allow the asset to be pulled back into the grantor's taxable estate. Let me get to the full list of what you can do, what terms you want to allow. Okay, so there are 4 categories of the administrative powers that can cause a grantor trust to the owner, and I just mentioned them, but I want to go through them completely so you're clear. So what causes grantor trust status? It has certain terms of the trust that trigger that. And again, this is laid out in the Internal Revenue Code I quoted earlier. Dealing for less than full or adequate and full consideration. So essentially exchanging or disposing of assets for less than the full value of it. So if the grantor non-adverse party is involved, then they have to get the consent approve of an adverse party. So it makes it a little bit complicated to include this provision. I mentioned borrowing without adequate security or interest. And so that's another power you can give to the grantor that causes it to become a grantor trust. Borrowing of the trust funds for inadequate security. So if the grantor has borrowed the corpus or income without having, completely repaid the loan before the beginning of the taxable year, the trust actually becomes a grantor trust. So they have ability to do that. The fourth power is, again, the ability to exercise or vote directly on corporate stocks or securities or control trust investments. So that is another power in there that would cause it to be a grantor trust. So going back to the intentionally defective grantor trust, I find it interesting because the client sometimes gets tired of paying the tax. I mean, again, it sounds very counterintuitive that they're giving the asset, they're not getting the income, and they still have to foot the bill. But again, from an estate and gift tax perspective, it's just a really great strategy. But, I had a client call me and say, over time, he had gifted the vast majority of this very large commercial property to his daughters. And he's like, I'm 80 years old. I'm really tired of paying this income tax. I just don't want to do it anymore. So you have to, again, this is another, I wouldn't say drafting error, but an issue if it's not incorporated. You can give, like, for example, the trust protector the ability to change it. And so in this case, this client would not appoint a trust protector. Because that trust protector has so much authority and power to change the terms of the trust, he just could never get beyond trusting someone enough to do that. And I said, we've given away this asset. It's not even yours anymore. But it was just a mental block. He just could not or did not want to do that. So fortunately, we're able to modify according to the probate code section, where it allows all the grandkids and kids to sign off on this modification, to make the modification without having to go to court. When we made this modification, I said, well, now do you want to just add a trust protector in there so we can have it in the future if there's any other changes? He still would not do it. The other thing that I typically put in there, just so it's clear, it's not a good idea to what we call toggle back and forth in the same taxable year from grantor to non-grantor. Like, oh, I'm going to do it, then I change my mind. You just know, I mean, it gets really messy. And I think there's also some different viewpoints on whether you can go back and forth and at all. I tell people kind of, once you do it, it's really hard to change it back and forth. So, but later in life, I find that they're just tired of doing it, and it might be clear that they really don't have a taxable estate, one, because they've given this gift, and it's just, again, very clear. So I think it's important to note that if the client chooses to set up the irrevocable trust as an intentionally defective grantor trust, figuring out a way to be able to change it if they're tired of paying those income taxes at some point. I think before recommending the use of an irrevocable trust, I think you really, this is also comes down to making sure, you've counseled the client properly. So I think in the last few minutes, I think it's going to making sure that you're aware that this is irrevocable. If you're giving it to a beneficiary, if they don't have that investment experience ability to manage it, then choosing your trustee wisely, I think, is really important. And that was talked about, I think, a little bit earlier by Larry, maybe having a third party beneficiary. Sometimes I think the client needs to understand the control they're giving up. And if it's a small business, look, you can create non-voting and voting shares and address that control issue. But I think with a small business owner their life has, been around this business, to give it away, I think becomes sometimes very jarring, and it takes some time to really counsel them to make sure they're comfortable with it. Obviously, the biggest downside that the kids need to be aware of is the lack of a step up in basis. So the extent that they're going to sell this property in the future, they should know they'll need to figure out or just simply pay capital gains tax on that. And I think that's important as well too. I think you'll see in the samples and drafting tips that you have there, the vast majority of the tips that you'll see are around encouraging you to include some way of as much flexibility without actually jeopardizing the intent to accomplish the trust. So the ability to change the trustee or the power of appointment, you can still give the grantors the ability to appoint and change their mind upon their death. Okay, I gave this gift to 4 kids, but I really just don't like how one is acting. Do I still have a limited power of appointment to reallocate amongst those shares? They may want that. They may want their spouse to have that. Courts have definitely held that just holding on to the right to change the trustee is not enough to pull it back in the taxable estate. But definitely, I tend to explicitly write in that the grantor is not able to appoint themselves as trustee. I just stay away from that. The other thing to keep in mind, another drafting tip, and you want to read up on if you're creating these, intentionally defective grantor trusts or another type of intentionally defective grantor trust that gives the spouse access to it, often known as a SLAT, spousal lifetime access trust, that you're not running afoul of the reciprocal trust doctrine. Ultimately, that's going to then cancel out those, and you want to carefully draft that as well too. Question came up: can we transfer an LP, a limited liability partnership interest, without increasing property taxes? So same example or rule that I gave with the LLC. Rule applies to the LP rule, a limited liability partnership. So you can gift up to 50% of that LP interest. It's a change in control. When more than 50% changes control, it triggers reassessment. But you can transfer an LP interest to an irrevocable trust. Now, a living trust. So I guess the question was about a living trust. Absolutely, because assuming the proportional ownership of the limited partnership interest is the same as the beneficiaries of the trust, right? So you can't, and you have to be careful in a married couple situation if the husband is the only owner on the property, transferring it into an LLC or into a trust, that the proportional ownership needs to take the same. But a living trust is really simple because typically you're transferring your own assets into a trust that you're the beneficiary of. That is in no way a change in the control that's going to trigger reassessment. I was referring to, let's say, setting up an intentionally defective grantor trust for the children, let's say, then that you don't want to gift more than the 50% because it'll trigger reassessment. And there is absolutely instances where another question about one trust transferring an asset to another trust. Sure. And obviously, whether it's a gift depends on type of trust, right? If I'm going from my revocable trust to an irrevocable trust I set up my kids, then that's a gift. And it's a completed gift that I need to report and, may trigger reassessment. So obviously, from one living trust to the other is kind of fluid if I'm the same beneficiaries. But if you're going from one trust where I'm the beneficiary to another trust I'm not, then that's essentially a gift, right? And you need to report the gift. But certainly there are instances where that would occur. Let's see, waiting to see if we have any other questions. The special needs trusts are really complex. I would say, I've presented just on that alone. So if you are interested, it's a very rewarding area of law where you're helping these families, but you need to definitely do your homework and take a look at that. Okay, last question. Under what circumstances might a client benefit from toggling to a grantor trust on and off? And what legal and tax implications when they're looking at that? Honestly, I love intentionally defective grantor trusts, so I like to keep that going because, again, it's such a way to make additional gifts without having to report them. But the example I use is they're just tired of it, and they don't want to be paying the income tax anymore. I definitely think it's more advantageous for them to continue to pay it if they have a taxable estate, but if they just don't want to, or maybe, again, they've done enough gifting and their estate really isn't going to be subject to estate taxes, then toggling it off makes sense. You just have to be careful to make sure that you're working with the CPA so that they look at, okay, as far as this calendar year we toggled off, and they just need to adjust the reporting on it. And so I tend to tell my clients, keep it in place because I like it from the long-term strategy. The CPA will kind of say, well, you sure you really want to keep paying this income tax? And then they need to know, okay, the trust is going to pay for it. So you need to advise a client, if the income is not being distributed out to the beneficiaries, the trust, an irrevocable trust pays at the highest income tax rate at about $12,000 or $14,000 worth of income. So it hits the highest tax bracket and the highest tax rate early on, versus the individual beneficiaries do not. They hit it, will they pay it, whatever their income tax rate is. I